All new at 5:30, CBS 6 continues our weekly Power and Politics segment.
And tonight, our Tom Eschen sitting down with James Murphy, the now former Saratoga County judge. He retired in February. He's in a new role now with Big Communications, and he spoke about that and much more with Tom.
Yeah, thanks so much, guys. Appreciate it. Now, criminal justice reform has been center stage over the course of the last few years, basically since those laws were enacted back in 2019. Discovery law changes, as we've been telling you about, taking up most of the air in the room when it comes to this budget, delaying the state budget at that well beyond its date of April 1st. Now, we've spoken with prosecutors, public defenders. Tonight, as you mentioned, we speak with a former judge, James Murphy, and we start that part of the conversation talking about the push to codify People versus Bay, which ruled if a prosecutor is acting in good faith, doing due diligence, a case would not be dismissed based on a technicality.
Well, I have read that case, and I think, sometimes the criminal justice system needs to be able to be changed, right? It can't be absolutely 100% solid without ever changing. And I think we had years and years and years of no change. And so as a result, the pressure to change the criminal justice system became overwhelming because things were just simply not fair anymore. On the other hand, we can go too far. And I think we did that in the initial bail reform stages, where we had people that went out and committed burglaries and then were released on RORs and then committed a new burglary and were released again and again and again. So that needed to be changed. So I think sometimes the pendulum needs to swing back a bit, but codifying the discovery statute is important for prosecutors to know institutionally what they need to do in every single case.
Right.
And I think as long as they know what the rules are and where the line is, they're going to follow it.
Other options other than dismissal, how would someone like you disseminate that and decide what that would mean? You know, who's calling the balls and strikes there?
Well, the judge does.
Yeah,
and it's always based upon the arguments that are before the judge, the prosecution and the defense. It's based upon the material that's submitted, what happened in the case as well, and then obviously the case law that applies to it. Dismissal is the ultimate sanction, right? Once you dismiss, it's over. And unless there's a bad faith, purposeful ignorance of the statute, then I think that time might be for a dismissal. But mostly the experience I've had is that there's so many moving parts in these cases. You know, hundreds of people touch these cases: law enforcement, social services, DAs, investigators, all kinds of people. And you have to be aware that it's not easy to get all that material in one place to a defense attorney within 15 days of arraignment. And that's the problem. And I think if there's a reason why, and it's articulated in a thoughtful and documented way, I think a judge would very easily be able to decide, I'll give you more time. I'll adjourn the trial. I'll give defense additional time for their discovery. So you can be fair about it without the ultimate remedy of dismissal.
Right. And I think those that have fought for these reforms would be concerned that they would go too far, right? In terms of allowing the case to go on, and then you have pre-2019, right?
Right.
I think that's where I think there could be some gray area and some concern among those that are saying, well, now you're allowing more leniency here, right? At the end of the day.
Right, and I think the danger is taking discretion away from the courts, because the courts are kind of in the trenches. You know, we see the cases every day. We know who the attorneys are, both prosecution and defense. We see what the track record has been, not only in this case, but in other cases as well. And so, you know, you like me make judgments based upon experience, contact, what you see, the credibility of the witness. And so you can make decisions based upon that, I think, that are always fair, given what you see as in a courtroom.
So you do think that in 2019 reforms were needed?
I think that, yes, I think in 2019
in discovery
reforms,
specifically.
In discovery, because defense was flying blind a lot of the way, and that was difficult. I think that there needs to be more tweaking, though. It's never done, and I think at this point the burden on prosecution is enormous, and I think that there's got to be a way to be able to accommodate the requests of the prosecution and the defense with something other than outright dismissal.
Let's get quickly to bail reform. I know it's not really a conversation right now at the Capitol. It has been since 2019, and there's been changes, tweaks to it, I think 2 or 3 at this point.
Right.
Should dangerousness be part of that?
So dangerous,
be considered for a judge?
So many states do consider dangerousness, obviously. One of the things that we look at is ties to the community. And I have always said, and this is kind of counterintuitive, that the people who have the money have ties to the community. So aren't we really saying that people who have no ties to the community, people that are indigent, homeless, are we treating them differently? So in essence, is that a double standard as well? So you look at dangerousness, is that not necessarily a better way to look at it? Because ties to the community is really, I think, defines someone by their socioeconomic status. And that's not what we want either. So I don't think there's any right answer. I don't think it's an easy answer. But I think that judges should be able to consider dangerousness in an appropriate circumstance.
Can they do it without using that word now? With what's in the wording of the legislation? Because I know a couple years ago there was a list of different things that you could look at, and then least restrictive means is in there now.
Right.
I mean, is dangerousness already, I guess, implied?
Well, dangerousness is kind of the elephant in the corner. I mean, you know what the charge is, obviously. The person in front of you is presumed innocent by the Constitution. They are sitting there just like you and me in a courtroom. They're presumed innocent. So you can't consider, the fact that they are charged with a murder, for example. You can consider what the potential sentence range would be if they were to be convicted, and if that, in fact, equates to likelihood of fleeing the jurisdiction. You can consider what are the likelihood of success on the merits of the case. You can consider ties to the community. Those are the kinds of things that judges can consider. You just go down the line. And so we do that, and we follow the statute.
Okay, so we use that part of the conversation, then apply it to the Lola burglary case. Remember that in Saratoga just a couple years ago, and why those defendants were set free to go when their charges were pending. So we get deeper into that, and also this narrative going around judges potentially making political decisions in this country. You'll want to hear what he has to say about that. Plenty to work through there, too. Back to you, Lara.
All right, Tom, thanks. That full conversation will be live as a podcast first thing Friday morning, tomorrow morning. Scan the QR code on your screen and listen wherever you get your podcasts.